Hello, everybody. Good evening. Welcome in. This is my pregame show that I like to do before I head over to the Tube of You. I will be heading over there here in a little bit to do a full live over there. I really only have one night that I'm confirmed on anything, and that will be Tuesday nights over on the Tube. But I do like to come on over here on the TikTok and hang out for a little bit, do a little pregame show, give you an update about what's going on, and see how everybody's doing. So, hello. Hi, Kimber. Welcome in. Welcome. Good to see you. Hello, Nancy. Mary May. Hello. I will still be over on the Tube here in a little bit after I finish up here. So, for those of you following me over there, yes, well, I will be over there. So let me just put that up here. Okay, so this is kind of the pregame show. Show here on the TikTok, and then we're heading over to the Tube. There we go. There we are. Hello. Oh, of course, Hawk Talk. Of course, I'm happy to do it. I mean, when I say I'm happy to do it, I mean I enjoy doing it, although I wish we didn't need to have it. Maybe that's the best way to put it. Hello. Hi, Joy, CT. Good to see you. Aaron, little sparkles. We love that. So I did want to come on here and just kind of check in with everybody. I went this morning and read through an order that has come out of San Francisco versus the administration regarding the sanctuary cities. And there's about, I don't know, maybe a dozen different cities as part of that particular lawsuit where the judge came in and said, no, you can't. Just threatened to remove all federal funding. So that was a very interesting case. I will have it posted up on the Tube pretty soon. It takes me a little time to get everything downloaded, then uploaded, and such. But I will have this morning's live. I think I might be 2 lives behind. So I'll have to think about that. I've got to get uploading quicker. I'll do my best. Medicaid update. Oh, I don't have one. I'm sorry. I'm so sorry about that. That is not one of the areas that I track, because what I've noticed is that there are some people though that track it and do a really great job with it. So I'm not sure. Does anyone in the chat have any people that are your go-to people for Medicaid, for keeping up to date on that and where it's at? I know On the Hill, I hope I'm saying her name right. She's doing a live right now, going through some of the things that are happening. So she does great work. And I'm not really sure the others. Do we have anyone hello, Thomas, good to see you. Anyone that you all like to go to for the budget stuff? I'm just not good with the budget. I just cover my eyes. I don't want to watch. How many lawsuits are we up to? We're almost at 250. And, I'm rounding up. So we have less than 250, but we're almost there for lawsuits. Oh, she was indicted. Oh, my goodness gracious. All right. Well, let me make a note of that. I'll have to pull that indictment. There we go. We'll see how that goes. Hi, Kaya. Welcome. Oh, my goodness. Oh, thank you so much. Oh, look how pretty that was. Oh, that's just lovely. Oh, I appreciate that. Yes. I will be taking a look at that case. I want to look through and see how the indictment came about. Now, I'm wondering if it was a grand jury indictment or not. That, to me, will be pretty telling. Most places... Well, hold on. If it's a federal charge, it would be a grand jury. So, yeah, right? I'm not sure, actually. I'm not sure what exactly she's been charged with. I'll have to take a look. But if it's a full grand jury, that should be very interesting. Followed some of the Diddy trial. Oh, yeah. Oh my gosh, J-Jack, I tell you what, I will glance at the sketches of the courtroom sketches and then I will look away quickly. There's another case going on too in Manhattan that is just, oh my gosh. The details are just, oh my goodness gracious. Two ladies that were running kind of a scam, kind of along those same lines, honestly. And it was like a yoga, with benefits, plus benefits kind of situation. And it turned into kind of like a madam situation. But anyway, they're on trial right now. They're on trial fighting for their lives right now. And I think that that's okay. Normally I don't say that, but I do. For this particular case, it's a tough one. I looked through a little bit of it, but then I was like, nah, I'm not going to do that. I think I posted yesterday or the day before on what it was. So if you go back into my posts, you'll be able to see the case name and the case number if you want to look it up yourself there. Hello. Hi, June Marie. Hello. I know, me too, Thomas. I'm with you on that one. I just need a good old fashioned homicide, whatever. But when we get into those special or SVU places, it's really difficult. It gets to be a lot. Yes, it just gets to be a lot. So this is my pregame show tonight, everyone. I am going to be heading over to the tube here in just a little bit, but I wanted to come and hang out for a little bit here, give everyone, I've got a stack of paperwork here, and I thought, well, we can go through that. I'll be going through the Abrego Garcia update. I'll kind of just touch on it a little bit, I think, here during the pregame show, and then we'll head over to the tube and I'll read through the latest update on that. So, yeah, so Felix, great question. I think that's going to be a really popular question tonight. I have not been tracking that for me. And I do apologize. I have to, I'm kind of maxed. I'm maxed out. Like Harvey Weinstein's case was back today. We've got the, oh my gosh, I just forgot their names. The famous brothers are getting resentenced, or they're having a hearing. Oh my gosh, what was the name? Those two fellas. Oh my gosh. What is it? Oh my gosh, it just left my brain. Menendez. Oh my gosh, Tony, thank you. Oh my gosh, Tony, I'm so thankful. Menendez. I know, I get it mixed up because we had the Senator Menendez case with the Egyptian golden bars. So, right, so we've got that. There's just so much going on. My mind's like, psh, it's just too much. Eric and Lyle. Yes, exactly. So, yeah, Mendez versus Menendez. It's an ongoing issue. But that's going on too. So there's just a lot. There's a lot going on. But I tell you what, the Medicaid situation is like, siren red flag. So incredibly important. So if anyone has people that they follow here, make sure to share that with the chat, who you go and keep an eye on to make sure that you know what's going on there. Is it Menendez? Oh my gosh. Jeff Clark. No, I thought it was Mendez, but Menendez, right? Oh my goodness. Right. Oh my goodness. Oh, yes, indicted. Yes. And I'll take a look at that too. That's fresh news for me. So I'll have to take a look at that. So Kohlberger, you're going to have to give me a reminder on the facts of that case. Which case was that one? And then I can let you know. Just, right. Menendez. Okay, it is Menendez. All right, now I think y'all are messing with me now. That's all right. Oh my gosh, I struggle with names, everybody. The Ohio College Oh, right, right. Oh my gosh. Yes, Kaya, thank you so much. For some reason, I feel like I've blocked the name in that case because that situation is just so, um, it's just tragic. I mean, all the way around. I really don't have many thoughts on it. I'm still waiting to get more information. So for me, I want more information because we've had some close call cases in that area. Can't get the answer from anyone. Oh, I know. Felix. Oh my gosh. I know. I tell you what, this is millions and millions of Americans are going to be affected by this. And then even within that, we have those that are in life-threatening situations. Absolutely. I mean, it's horrific. It's terrifying. Absolutely terrifying. Oh no. Oh, I know. Yeah, it's very this is a tough road we're on, everyone. Eric and Lyle, thank you very much. Menendez. All right, double N. Double N triple E. Got it. Got it. I got it. But anyway, so I get sidetracked, everybody. I got a little the ADHD. But with the Medicaid situation, there is a creator on here, and oh my gosh, I hope I just say her name right. It's On the Hill, I believe, is her handle, and she does amazing work. She's live right now, so if you did a search that was like live now Medicaid, you may find her on there because I'm so terrible to remember her handle. So gives me hope in QC saying, well, we'll keep going. We'll keep walking through this, one foot in front of the other. Sometimes it's just all you can do is just keep going, right? Hey, hi, Lucy. Oh, I love it. uh, I'm doing great, Kevin. Thanks for asking. Yep, I'm doing great. It's been busy. It's been busy. Oh, thank you so much. I appreciate it. Yeah, so everyone, I'm just waiting a few minutes to make sure everyone gets their notifications over here. So I'm doing kind of a pregame show, going through some of the things that I pulled and such over the last couple days. We'll just kind of chat about updates, and then I will head over to the tube, and I'm going to be doing a Garcia case update over there, and then going into that. So, no, not Candyland. Come on. What do we pay the peppermint fella for? Oh my goodness, I'm so funny, everybody. Oh my gosh, yes. So, are we heading over there? It's What the Hill. Okay. Thank you, Sarah. Oh my gosh, thank you so much. So let me just put this over here. I don't know why okay, here we go. Let me put this over here. So What the Hill is a creator here, and oh my gosh, she's just amazing. And this is all one word. Hopefully, oh my gosh, I'm sorry, everybody. This is all one word that I've done terribly. She keeps you posted on Congress, what's going on in Congress. Like, she has like the heartbeat of DC, right here in front of her. She's taking care of business and so incredibly knowledgeable. So if with this budget situation in particular, I've seen her posting about it and really keeping an eye on it. So that's where I would send you to. Just followed her yesterday. Love it. See? Great minds think alike. Upgrade. They do. I know. Okay. Is it separate? What the? Oh my gosh. Oh my goodness. Oh my goodness. All right. What the hell, everybody? It's What the Hell. Go and follow her. I think she's live right now. Tell her I said howdy. But yeah, she can give you some updates on what's going on with the budget. So that's a pretty big deal with what's going on right now in the budget. Okay. Love it. All right, everybody. She is okay. Excellent. Oh my gosh, I'm probably have her name incorrect. Oh, she's just so good. She is live. Okay, excellent. And it won't hurt my feelings if you want to pop over there and hang out. I mean, it's just great. She does great work. All right, everybody. Well, welcome in here. Let's go ahead and get started. This is my bonus live over here on the TikTok. I will be heading over to the YouTube here in a little bit after my pregame show here with everybody. Let's see, what do we want today? Maybe we need a drumstick. I feel like today's a drumstick day. Okay, we got our drumstick ready. Yeah, so she just does, a lot of people are asking about what's happening with the budget bill that's going through, right? So I'm just saying, she's a great creator and she's got her finger on the pulse of DC. So for anyone who's interested in that. Okay, really? Oh my gosh, Sarah. Oh my gosh. Okay. I was way off. In the know. Oh, well, there you have it, Thomas. That's what we gotta stick together. All right, thank you, Sarah D. I appreciate that. And I'm really sorry about the names. All right, so here we go. This is the first little group. I don't know. This is the first document I've got here on my desk. These are things that I just wanted to share on different lives. I'm just kind of doing a little quick action here. So this is a lawsuit that was filed by the Robert F. Kennedy Human Rights group. I don't know, is it a group? And this is a nonprofit organization, and the Southern Border Communities Coalition and Urban Justice Center against the U.S. Department of Homeland Security and Kristi Noem. Now, I know we've got a lot of cases going, but this one is just, oh my goodness, this one's really, yikes. When I was reading through it, I thought, this is just awful. This is some bad business. So we have here, let me just read you the first couple paragraphs, give you an idea. Since passing the Homeland Security Act in 2002, Congress has sought to balance the need to defend national security with the need to protect the privacy interests and civil rights of individuals. To this end, Congress created 3 offices within the Department of Homeland Security dedicated to protecting individual rights and interests. The Office for Civil Rights and Civil Liberties, so this is the CRCL, Civil Rights, Civil Liberties Office, the Citizenship and Immigration Services Ombudsman Office, and I guess they're just calling that the CIS Ombudsman Office. I guess. Okay, that's that's not a very good acronym. Like, if you're going to do an acronym, you can't leave a word like ombudsman in it. And the Office of the Immigration Detention Ombudsman. See, this one over here, all right, so OIDO. Oh my gosh. All right, see the O right there. So this should be like CISO. All right, here we go. So the Civil Rights, Civil Liberty group is charged by statute for receiving complaints about civil rights and civil liberty abuses by DHS, conducting public outreaches so people are aware of the ability to file complaints, and so on. Here, and I'm going to just fast forward. Next, we have the CIS Ombudsman Office. Oh my gosh, we're going to just call it CISO, all right? Required by statute to assist individuals and employers who are having problems with visas, work permits, and other immigration issues, make recommendations to the U.S. Citizenship and Immigration Services, and so on. And then the last one, OIDO, required by statute to take complaints alleging violations of law, professional standards, and contract terms by operators of public or private detention facilities. They do on-site inspections of immigration detention facilities and assist those affected by potential misconduct. So guess what's happened, right? They're like defunding and dismantling it. So the defendant's actions are to eliminate these 3 pieces of the Homeland Security situation, these 3 different offices, and they're saying they're ultra virus, which means that it's an overreach of the president's power, and they violate constitutional separation of powers by flouting Congress's express statutory direction that these offices must exist. And that's true. Congress has set up a whole bunch of different offices, and they're trying to do away with them. So that's a problem. It's the same thing with the USAID situation, and perform various functions. Actions are also arbitrary and capricious, which is one of the arguments that you can make in these kinds of situations. So this lawsuit, which is just heartbreaking, is going through and explaining how we are losing the Office for Civil Rights and Civil Liberties, as was set out in P25. The Citizenship and Immigration Services Office, that's gone. The Office of the Immigration Detention Ombudsperson, gone. All right, so those three areas are gone now. So they are filing this lawsuit in order to rectify that situation. I will be going through and giving more information and doing a full post on this one, but it's just giving you a heads up on it because this is pretty awful. Pretty awful. Oh, thanks, Bay Grandma. Thank you. All right, so next, again, I'm just kind of going through my paperwork here as we head over to the tube here in a little bit. So I wasn't sure if everybody was aware, but on May 15th, so Thursday, all right, Thursday, we have oral arguments on the SCOTUS docket. So the SCOTUS docket has the regular cases that they, whatever, and then they have what we call the shadow docket, or those things that are like really emergency, exigent, we need to have this taken care of right away kinds of situations, all right? So we have the shadow docket up and running right now, which, these justices are going to get sick and tired, because let me put it to you this way. We have almost 250 cases going, all right? And for each one of those cases, there are preliminary injunctions being appealed up to the Court of Appeals, restraining orders, temporary restraining orders being appealed, and then those will go back. Discoveries being appealed, any kind of immunity is being appealed. So for each of those cases, they're going up and down the legal system. And some are making it all the way to the Supreme Court. All right, let me give you a visual here of what I'm talking about. So when we start in any federal civil case, we're at the district court, right? So this is where we review our evidence. All the evidence goes in through the district court here in our civil cases, all right? And then if you are having a problem, like with the preliminary injunction, if you think it's too, narrow or too broad, or the restraining order is not okay, then you appeal it to your circuit court of appeals, all right? So your circuit court of appeals is here. And then we call this an interlocutory appeal. Interlocutory, that's probably spelled wrong, but anyway, that an interlocutory means we are not even in the trial yet. We haven't gotten to the trial. We're so early in the case, and there is an appeal. They're upset about the judge doing something. So they send up an interlocutory appeal to the Court of Appeals. And so we've been seeing a lot of those with the AEA cases, right? The Alien Enemies Act cases. So here are all the circuits set out. And the DC Circuit is just the DC Circuit. But for example, we have the Alien Enemies Act case has been appealed up here in the Fifth Circuit in Texas. It's been over here in the First Circuit, the Fourth Circuit. I want to say one more, but I'm not sure. Anyway, so the point is, if you have an injunction or something else, you don't like it, you appeal to the Court of Appeals. They make their decision. Now, if you don't like the Court of Appeals decision on that preliminary injunction, then you can appeal it to SCOTUS. All right? And that's what has happened. That's what happened in the Garcia case, and also in the JGG case. We had the California teachers case that had to do with funding grants to teachers. Those are the cases that have gone up to SCOTUS already. Now, again, we haven't even had a trial. We haven't even had discovery. You know, if there were 50 different steps to a case, we're on step 2.5 at this point. So we have had preliminary injunctions go up to the Court of Appeals, and then the government has appealed it again to the SCOTUS. SCOTUS sends it back down to the Court of Appeals. The Court of Appeals sends it back down to the district court. The district court then says, all right, well, here's your new preliminary injunction. And so the next week comes in, and the district court says, all right, now it's time to start discovery. This is a process of gathering information. It happens in all cases, especially in civil cases. So the district court says we're going to have discovery. And so then the government says we don't have to give you any information because this is an executive blah, blah, blah. So the district court says, well, you're going to need to do interrogatories and depositions and produce documents. And he say, no, we're not, because it's the president. So they appeal it to the Court of Appeals. And the Court of Appeals say, yes, you have to do discovery. No, it's not protected by anything. You have to do discovery. So then they appeal it again up to SCOTUS. And then, you know, it comes back down again and we start again. So every single step of the way, the government is appealing everything. So if it's a preliminary injunction, if it's a restraining order, a motion in limine, motion for discovery, motion for documents, if they're upset about depositions, if they're upset about interrogatory questions, pieces of questions, every single solitary thing, and it will get bumped up to the Circuit Court of Appeals. Now, one interesting thing about the Court of Appeals is that you can do what we do with a 3-panel of judges, right? So they'll listen to it and they'll say, nope, we're not going to have, we're going to allow the preliminary injunction. So then not only that, but it's possible then to appeal the appeal to the en banc, which means to the entire bench of the Court of Appeals. So this is like a side quest appeal that's possible. Where does the state Supreme Court fall into place? Right, so I'm glad you asked. So don't forget about this. We have bonus here. So we start with a 3-panel court, and then, of course, they can bump that up. So, state court, let me set it out for you here again. This is all federal. This is federal, so any of those questions, U.S. Constitution questions, and so on. But this is for state law. Here's our process. Again, you start at the district court, then you go to your Court of Appeals, whatever it's called in your state, depending on if it's an old state or a southern state or whatever. And then you can appeal it to your Supreme Court, so the state Supreme Court here. Some states, actually, you appeal your first appeal over to your state Supreme Court, and they say, meh, it's not that interesting, and then they send it to the Court of Appeals. But ultimately, you know, what you do is you get this set of appeals to work your way up. And if it's a state law issue, if there's no constitutional question like U.S. Constitution, once your state Supreme Court rules on it, you're done. Except for New York, because New York Supreme Court is the district court because they're crazy in New York. All right? Does that make sense? Is the state SCOTUS only for state charges? Yes. So only state law can be heard by the state Supreme Court here in this situation. But if you have, I suppose one of the best ways to illustrate this is the marriage cases, right? So the same, I don't want to get myself into trouble using certain words, but how the marriage cases happened was that there was a local rule saying, no, you can't get married. That local rule was challenged in district court. Then it was appealed, all right? And then it went to the Supreme Court of the state, so the state Supreme Court. And then because it was dealing with a U.S. constitutional fundamental right, then it went up here into the federal court, all right? So there's two different systems here. Two different systems. This can cross over into SCOTUS if it's a constitutional question, if it's a federal question, but it's all about jurisdiction. And the state courts do not have jurisdiction to hear federal cases. If there's a piece of it that's going to ask a federal question, it will need to be transferred over here. All right? Does that make sense, everybody? Confusing it is. It is. They keep losing cases. I know. It's interesting because they keep saying, "Oh, we're winning," and I'm like, "You're winning what?" I mean, I don't know. Like most cases filed, most appeals filed ever, because again, when we are here, this is the where we're at right now. We're in the district court. We haven't even had a trial. We haven't even had pretrial motions, which can be interlocutory appeals, or rulings on different pieces of evidence, which can be interlocutory appeals. There, if you nickel and dime the crap out of a case, you can take every single question up on an interlocutory appeals up here. They answer, and then you appeal again up to SCOTUS. And so here's my prediction, right? My prediction is the government, the DOJ, is going to start appealing all of the Circuit Court of Appeals decisions. And now the Supreme Court's going to be having questions like, would 23 interrogatories be okay instead of 20? That's where we're going to get to, because they're nickel and diming everything. And SCOTUS took such a micromanagement position on so many things that these 250 cases might go up to SCOTUS 2 or 3 times until SCOTUS puts their foot down and says, we're not going to do it. Or the Court of Appeals is like, no, we're not taking the appeal. So they have to kind of get a bit of a backbone and say, no, we're not going to do this. We've already heard your case 5 times. We're not going to appeal it again. And SCOTUS has to say, we're not going to deal with it. That's not happened yet. That's why we had the Garcia case go all the way up, then all the way back down. And JGG went all the way up, then all the way back down, then over to Texas, right? Take care, Real Life Works. Have a good one. There's really not any clock running to do. The only thing that's happening is, and that's the other problem too, is if there's a preliminary injunction or a restraining order, what that does is it stops everything until the litigation moves further. So right now, what's happening, which brings us all the way back. Here we go. We're all the way back, everybody, to this case. This case is one of our birthright citizenship cases. It's actually one of 3. There's 2 more, and I can't remember. There's 2 states, but I can't remember. I think it's like Maryland, maybe, but I don't know. Whatever. They're all together. This one just happens to be the one that I printed, which is CASA. Now, they had asked for an injunction on the birthright citizenship executive order that came out, right on, hold on a second, let me just double check here. Let me see, right, let me see. Continuing or restoring common sense, no, that's not right. Establishing, implementing, no. Oh, wait, maybe it's this one over here. Okay, hold on just a second. Securing borders, that's not right. No, this is environment here. These are the, improving education, no, that's not right. All right, well, let me see here. That's going to drive me crazy, everybody. I've got to find it, or it'll drive me crazy. Oh, my goodness. All right, here we go. So, America First policy, application for protecting Americans, designation as a foreign T organization. This is all foreign policy, so... national security. Let me see. Let me see. I don't see it. Oh my gosh, was it a proclamation? Oh my goodness gracious, proclamations. Are you kidding me with that? Let me see. Just 1 second. This is gonna drive me crazy. Restoring penalty here, protecting American people against invasion. Emergency water, paper straws. Criminal aliens. Security. Okay, I think it must have been. It must have been. Oh, maybe it's in here. This might have been it. Okay, sorry everybody. Just looking for the executive order. This is the closest one I think we've got here. I gotta check the door. Oh my goodness. It's helpful, but the executive orders just have such a huge name. Oh my gosh. So anyway, I think this is the right executive order. And what happened then, let me just look through here real quick and make sure I'm in the I'm close here. It couldn't have been a proclamation, right? Okay, it was Washington and New Jersey. So I was thinking of Maryland and New Jersey. They all blend together on the East Coast. I'm sorry. Hold on. Here we go. Let me just make sure I've got the right. Okay, here we go. January 20th, executive order concerning birthright citizenship. All right. I think it was this one, but I may be wrong. The point is, the reason why that took a lot of time. We were off-roading there for a minute, all right? So the birthright citizenship, and I think it was actually the Washington State, that was the first one that issued a preliminary injunction. And they said, no, we have a case law that says, citizenship. It's called, oh my gosh, I'm going to get it messed up. I know it's Wong and I know it's Ark. But for some reason, I always miss the third one. Yikes. Is it Kim? Wong Kim Ark? Is that right? Oh my gosh. Anyway, so that's the case. It was in the late 1800s. And then we have the citizenship clause of the 14th Amendment. All right. Is it Wong Kim Ark? Oh my gosh. Oh, thank goodness. Thank goodness. I was like, wait a minute, I'm missing one. I got the first, the last, but I don't have the middle. Okay. Anyway, so the preliminary injunction's like, look, we've got precedent from 100 years and the Constitution, so no, you can't just stop birthright citizenship. So the injunction went in. The question became, can the court do an injunction for the entire United States or just for their circuit, right? That was the huge issue. So Washington's up here in the Ninth Circuit, and they're like, well, you can only do an injunction for your states over here, like Alaska and Hawaii. I didn't know Alaska and Hawaii were part of the Ninth. That's interesting. Sorry, my ADHD is just running wild today. All right, so they're saying, hey, the Ninth Circuit shouldn't get to decide what's going to happen over here in New Jersey, which is in the Third Circuit, or CASA, which is wherever. So that's the question. We do have this issue of birthright citizenship, but the ultimate question here is not deciding that actual issue, all right? So we have to remember that. We're not actually listening to the Supreme Court decide whether or not birthright citizenship is okay. I mean, they may somehow come into that, but what we're asking is whether or not universal injunctions improperly grant relief to non-parties. Meaning, does whatever injunction put into the Ninth Circuit incorrectly assert its jurisdiction over the Sixth Circuit? This is huge because we've got so many preliminary injunctions going on because we have 250 cases. And in each case, you need to pause some things in order for there not to be potential harm done. There's a test that all the courts use to go through and make sure. So the question before the U.S. Supreme Court is, can one circuit put an injunction good for the entire nation? All right, that's the big deal. Is it Maryland? Okay, maybe that's where I got Maryland from. D. Marie, you'll have to give me the case on that one. Yeah, you'll have to give me the case. Is it the AARP? Is it DVD? Is it the JAV case? Which case is it? I think we've got about 10 Alien Enemies Act cases going, so you'll have to be specific. Anyway, so here we go. This is an application for a partial stay of the injunction issued by the United States District Court for the District of Maryland. Well, there we go. There's Maryland right there. Here. So, they're coming in and they're saying, like, look, is this going to work? Now, this question was also brought up during the, Biden student loan stuff. So we already have had rulings that have said, yes, it can. But then we've got jurisdictional questions on restraining orders as well. And we've been seeing that in the Supreme Court's most recent decisions in Garcia in the JGG case, where half the justices are like, we shouldn't even be hearing this case. And the other ones are like, yeah, we're going to do it anyway. Actually, in the JGG case, it's just crazy. They turned a restraining order into a preliminary injunction. I'm like, what, with a magic wand? Like, what's happening here? How did that happen? I don't know about that. I don't know about that. If these would disappear, because we still have the administration. All right, so that's what this case is about. The big cases, the precedent here that's been set. Let's kind of pull this out to take a look at. Labrador v. Poe, which was a 2024 case, so very recent. Then we had Trump v. Hawaii. This is huge. This is a huge case we're going to see a lot about. This has to do with presidential power. This was over the travel ban. And ultimately what happened was he left office. And so it became moot because when Biden came in, he immediately canceled that executive order. So we've got another case, DHS v. New York here. US v. Texas here, and then just over and over and over again. This is another huge case as well, going down the road. So that's what we're going to be listening to on Thursday. We're going to be listening to this question of how far can one circuit court of appeals injunction, how far can it go? Because it's already been held that it can cover the whole country. But now they have a different person who's in office and they're like, well, we don't want it to cover the whole country now. We want it to only cover that particular circuit, which, again, all of our circuits are splitting on these issues. So, it's kind of a hassle. It's kind of a bad situation. Yeah, do we know the name of the Alien Enemies Act case that you're talking about? Do we have a name for that, or are we just like pontificating? Yeah, because we basically now have 3 circuits that won't allow the Alien Enemies Act. And there is not one in front of SCOTUS. So it would have to be a specific one. What happened to stare decisis? Great question. That's a really great question. I think stare decisis went out when Obama's nominee to the Supreme Court was denied, just for funsies. Jeff Clark, what's the case name? You have to give me the case, a name. I don't know any of the judges. Yeah, so they're saying that one of our circuits has okayed the AEA, but I'm not sure which case it is. I gotta see the case name. How many circuits are there? Is it like we have 11? I think it's 12 if we count the DC circuit, right? That sounds right. Or is it 13? Oh, well, I think we've got 12. We're gonna go with 12. That's what we're gonna do. All right, so that's what's going on in this case. Is it 13? Okay, thanks, Peggy. I appreciate that. I was like, wait a minute. I thought there were 13. So, right here. Yeah, because we don't have names over here. All right, there you are then. That's what's going on in SCOTUS on Thursday. So keep that going on Thursday. I don't know how the arguments are going to be. I need the case name, right? So without the case name, I can't verify anything anybody's saying. So I have to have that case name. And that's what's so interesting too about the press is that they put out these like shock and awe statements, but you got to go back to the original source because that reporter may have been reporting it wrong. Or it may have, and again, I don't know who Judge Haynes is. I don't know who any of these judges are. I know a judge in Florida, but other than that, I can't even remember the DC judge. So I don't pay attention to who the judges are myself, everyone. Forgive me. All right, here's the next one that I've got printed out that I thought was interesting. Hong Zheng, I think, plaintiff versus Daniel Driscoll, the secretary for the Department of the Army. And Judge Chutkan, Bruce Wayne's mother, of course. How could I have forgotten Judge Chutkan? Shame on me, shame for shame. Oh my gosh, that one, I took a hit on that one. We have an interesting situation here, supplemental argument in support of relation of the Fifth Amendment review and preliminary injunction. So we've got a union here suing the Office of the Personnel Management. Okay, what case is it? Oh my goodness gracious. What's the name of the case? Oh my goodness. I can't. Oh my gosh, everybody. Oh my goodness. Oh wow. This is so fun though, isn't it? Look at all these people like saying, well, let's look through the case. Let's go through the case and then try to figure out what it all means. That's amazing. I think that's really fantastic. All right, so this is document 212. It was filed on the 5th of May. I'm going to still try to keep us on track here. Comparative harms and so on, Title 10, standing institutional rights. So I thought this was just interesting because we had the union versus the Office of Personnel Management here. So if anyone wants to look into that Fifth Amendment claim for expedited, ASR, really? Okay, do we know what court? ASR v. Trump. Okay, we gotta follow it. We're tracking it down, everybody. In Pennsylvania. Okay. All right, hold on. Here we go. Going around the bend. I don't know. The crazy bend. Oh my goodness. Oh my gosh. Okay, hold on. I'm gonna get it. Here we go. Oh my goodness gracious. Here we go. I've got ASR v. Trump out of Pennsylvania. So let me see here. SRV, ASRV. V is separate. V Trump. That's so funny. Oh my goodness. All right. So it was filed April 15th. Interesting. Let me look here. It's a habeas corpus case that was filed April 15th. Order the court. Motion for class-wide preliminary injunction. Hereby order the motions granted. What? Hold on. Proclamation of the invocation of the Alien Enemies Act regarding the invasion is further ordered. Respondents, any person here are enjoined, unless respondents first provide motion here. All right, hold on, everybody. I've got my. I'm yelling at you from across the room. Here we go. Just a second. We have the case implicates significant issues in resolving those issues. Obligations to apply the laws written. finds the proclamation now at issue complies with the AEA. Court further finds respondents must provide greater notice to those subject to removal. All right, then they're currently doing. All right, well, that's interesting. Okay. Venezuelan Alien Enemies Act. All right, I'm printing it right now, everybody. I'm printing it right now. And we can take a peek at it. I tell you what, the legal world right now is just bananas. Thank you so much, John. Thank you. Thank you, everybody that helped with that. Thank you very much. I appreciate it. Everyone's like, this happened. Like, where is it? Then we find it. So I'll take a look at it. Let's skip through this one. And this is the one I did earlier today. Hold on, let me go grab the file. All right, I just have the first few pages. We can just start talking about it right off here. My cat really likes my printer, so I had to get her off of the printer. All right, here we go. How do we find the case numbers? Yes, so that makes it tough. You can usually follow back whatever media outlet's putting it up, right? That's probably where you're hearing it from, is some media outlet. What you have to do is get the name of the case and then go backwards from that. So you would put in, ASR v. this word, and then case number, ASR v. this word, and then case number into search, and it should pull it up. Yeah, she's not happy. Oh my goodness gracious. Yes, exactly. And VC is like a pro. She can find a case, like even if you're just thinking about half of a name, she can trace that case down. So it's not easy. It's not easy doing it. All right, well, here we go, everyone. All right, Judge Haynes here, Venezuelan man currently in immigration custody, represents he's subject to the proclamation here. Oh, it is a proclamation. What? Come on. Pursuant to the Alien Enemies Act, seeks preliminary injunction. And right, we're in Pennsylvania. So let's take a peek. That's the third. We're in the Third Circuit here. Now, keep in mind over here, New York has already decided you can't. Texas has said you cannot. And then DC has said you cannot. So we've got multiple places here. So here we go. Specifically, he's asking the court to find the proclamation does not comply with the Alien Enemies Act, deem insufficient the due process that the executive branch is currently providing to those detained pursuant to the proclamation, and 3, afford him certain additional relief. So let's break this down right off the bat. I can see where we're going to get into some trouble here with understanding what's going on. Just write out, hold on, I got to get the perfect pen. There we go. So the first thing when we're looking at this, again, I've not seen any of this, but the first question, find that the proclamation does not comply with the AEA. So we know the Alien Enemies Act here. And so what we're going to need to look to is the exact language of that proclamation. That's not how you spell language. Oh my gosh, stay in school, everybody. I did stay in school, but we still make mistakes. All right, number 2, insufficient the due process. So they're saying the due process isn't enough, and that's probably because of the notice question that was raised. And then 3, he's asking for additional relief. Now, this extra relief, I don't know. So the language in the proclamation does not comply with the Alien Enemies Act. So it's very possible that the language can be fine with the Alien Enemies Act. But, we'll see. So the court is not... Okay. Oh my goodness. So first here, be cool, stay in school. First, this court is not resolving the question of whether the President of the United States may direct the removal of certain individuals when he acts pursuant to provisions of law other than the AEA, namely the Immigration and Nationality Act. So she's saying anything other than the AEA, that's not my business. Second, the court is not resolving the question of whether the President of the United States may remove under the AEA individuals who have simply migrated to this country, all right, as opposed to individuals who have entered this country and are members of an organization. So that's huge. She's saying, I'm not going to make that determination. The court is likewise not resolving the question of whether the president may remove under the statute individuals who are members of this here, as opposed to individuals who have entered the country and are members of this group. Okay. And third, the court's not resolving the question of whether individuals who are subject to removal under the AEA are entitled to sufficient notice, as will allow them to actually seek habeas relief in the proper venue before such removal occurs, citing the Supreme Court. So she's not resolving the question who are entitled to. Wait a minute. That's weird. Let's take that back a minute here. The court's not resolving the question of whether individuals who are subject to removal are entitled to sufficient notice. All right, so this particular break in language, she's saying notice versus sufficient notice. All right, fine. The Supreme Court's already found that they're entitled to such notice. Thank you very much. And this court has every intention of requiring reasonable notice, as it explains in more detail below. All right, so she's saying the Supreme Court said notice, and it needs to be reasonable. Instead, the question that this court is answering, 5 paragraphs in, thanks. Here we go. The question is this: so long as the government provides sufficient notice and due process, may the president issue a proclamation pursuant to the AEA directing the removal of 1, Venezuelan citizens, 2, who are 14 years of age, 3, who are within the United States, 4, who are neither actually naturalized nor lawful permanent residents, and 5, who are members of this group, which is a foreign organization. After extensive consideration and for the following reasons, the court answers that question in the affirmative. So let's make sure, oh my gosh, this judge, oh dear. Let's be really clear on what the question is here, everybody. Can the president issue a proclamation? Right? May the president issue a proclamation regarding the Alien Enemies Act, asking for the removal of these 5 different factors? And she's saying yes. Are you kidding me? Come on, man. Oh my goodness gracious. So he can issue that proclamation, is what she's saying. Because the court finds the president may issue a proclamation, not this proclamation, pursuant to the AEA directing the removal. Here, under the AEA, the court denies in part the petitioner's motion for preliminary injunction. So she's only denying part of the preliminary injunction, which means the other part of the preliminary injunction is in place. This is crazy town. All right, hold on. Let me go grab the rest of the case. Oh my goodness gracious. gosh, what are you people doing? Nutter butters. This is just ridiculous. Can he issue a proclamation? Yes. Is this proclamation okay? I'm not answering that. Like, what? What? All right, all right. So here we go. Oh my gosh. The court also finds that the notice that the executive branch is currently extending to individuals subject to removal is deficient. So he can do a proclamation, which I think is important. And two, the notice is not enough here. Not enough. All right. No, well, right. Yes, Navy vet. I know, right. That's the thing. So before I go diving in here, oh my gosh, this is just, come on. Just sometimes these lawyers are like just too much. Like, speak properly. According to the court, grants in part the preliminary injunction, and the court will require the detailed notice that the court outlines below. Great. So here's the background of the proclamation here. I want to go forward a little bit into her analysis where she's saying this proclamation is okay. We've already kind of gone through that. Found that, and I don't even know. I don't even know. Here we go. 14 older members of this within the United States. Okay. Because the proclamation references the fact that the Secretary of State deemed this group an FTO pursuant to Title VIII, here, the court briefly overviews certain portions of that statute. So this ultimately is going to be a SCOTUS question here, right? So we've got, that's a huge SCOTUS question. The provisions of Title VIII of the United States Code here. So she's going through and adding a justification in for how this group could be, oh my gosh, how this group could be actually working for the government. I wonder if it's going to be like Texas. Was everybody with me when I went through the Texas order? Because he had said the AA was not okay, but for a different reason. And he had actually found that this group was an extension of the Venezuelan government. Do we all remember that? Right. So if there's 3 points in Texas, he said number 1's missing. And so you can't use the AEA. So what she's saying then is, for her, number 1 is not missing. So you can use it. That's just ridiculous. All right. Here we go. Moving forward. National security. Oh, I can't. Oh my gosh. Okay, I'm just skimming through. Here's the test that we use to set aside the designation. Again, I'm not sure how this is appropriate here. The Texas judge went in and specified like the makeup of the group of people and how they were interconnected with the Venezuelan government. Like, that's how he justified his. But she's talking about Secretary of State, and she's talking about the authority that the Secretary of State has. And that looks like that could go too far as well. Yes, thank you, VC. That's right, correct. Okay, record evidence in support of the proclamation. Set forth the following 2 declarations in support. So the one is the one when they designate this as a T organization, right? And here, oh my gosh, she's citing the Kozak Declaration. Are you kidding me? Right. Made statements in his declaration based on his extensive, oh my gosh, this is a huge credibility issue. That would be a huge credibility issue. Sorry, everybody. This is my first time looking at it, so I'm just going through it like I normally would anytime I see a first order, which is This is crazy. We're in crazy town. So this fella here, Deputy Assistant Director, so she's relying on these two declarations and the Secretary of State. So that's where she's coming from, is what it looks like here. So she's saying these two, oh my gosh, are you kidding me? Let's read to the end here. Mr. Kozak made the statements in his declaration based on his extensive experience engaging in diplomatic work in Venezuela and elsewhere, as well as personal knowledge. According to Mr. Kozak, U.S. government officials from the White House, Department of State negotiate at the highest levels, right? And with Nicholas Person and his representatives, blah, 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 blah. Some of the members here were recently reached to this effect with these foreign interlocutors to accept the removal. These arrangements were the result of intensive negotiations. Oh my gosh. So this judge is just using the written statements out of the JGG case in DC, which I thought those statements were ridiculous and were not authenticated, but she's just going to take their word on it and Marco Rubio's word and say, based off of that, then, you know, this act is okay to use. Whoa, this is bonkers. Wow. Oh my gosh. Wow. All right. So this judge, I don't know who this judge is. I don't know anything about her. Stephanie Haynes here. Let's go through. I'm going to fast forward it a little bit here. Fast forwarding. Imminent removal. I'm just fast forwarding. Again, I just printed this out. It's still warm. Here we go. What? Motion for preliminary injunction. So is she saying then she's going to rely on these two declarations in Rubio for enough of a justification for a preliminary injunction because it has a lower level burden of proof? Is that's not right? I mean, because this is a habeas case, right? Hold on. Let's double check here. Currently in immigration custody, representing here. Is this a habeas case? Can we call the judge out for not using primary sources? Well, yes, we can. Here we go. I'm fast forwarding everybody. I'm trying to figure out if this is habeas or not. I don't know what other kind it would be other than just he can't do this. But if he can't do that, then you still need to have a core. The next order may help. Oh dear, I've only got this one. All right, so the Supreme Court's interpreting the meaning of the words in the term within the AEA, such as invasion and predatory incursion. It's JAV case. Likewise, consider questions, how notice is due, and so on, right? Court may theoretically assess the constitutionality of the AEA, although that issue is well settled in favor of the act. Oh, I don't know about that. Noting there can be no question the AEA is constitutional, right? The AEA is not what the question is. It is habeas. Thanks, BC. There's no question the AEA is not the issue as to whether or not the AEA is constitutional. It's that whether or not it's applicable here. All right, still skimming everybody. So, okay, here we go. This is where she's pulling in the, it does sound pretty funky here. All right, here we go. In this same vein, the United States District Court for the Southern District of Texas recently concluded. So I think that's what she's done. I think she's taken the Texas ruling and filled in the hole that they had in Texas and said, well, now we don't have that same issue, so we're good to go. Concluded that after a court construes the meaning of statutory terms such as invasion and predatory incursion, it's left to the executive branch to determine whether an invasion or predatory incursion has occurred. As to this decision, the court may not delve into whether the executive branch possesses sufficient support for its conclusion or whether the court agrees with the executive branch's determinations. No, that's not the case I was thinking of. Interesting. Indeed, that analysis would require executive branch to disclose to the court the domestic and foreign intelligence that undergirds the finding of an actual or threatened invasion or predatory incursion, which would be contrary to law. All right. And then she's citing here. That's not the case either. You're not pulling up the cases that I thought she would pull up. Here we go. Therefore, this court may not and therefore will not assess the truthfulness of the statements in the proclamation. Whoa. Oh my goodness gracious. Let's read this again. I must have read that wrong, everybody. I have no cuticles left, John. All right, let's read this again. That can't be right. Judge, there's no way that the judge put that there. Indeed, that analysis would require the executive branch to disclose to the court the domestic and foreign intelligence. Well, let's back up again. Let's back up. This doesn't make any sense. In the same vein, the United States District Court for the Southern District of Texas recently concluded that after a court construes the meaning of statutory terms, such as invasion and predatory incursion, it is left to the executive branch to determine whether an invasion or predatory incursion has occurred. Right. As to this decision, the court may not delve into whether the executive branch possesses sufficient support for its conclusion or whether the court agrees with the executive branch's determination. Right? I mean, that is part of the precedent, and they are saying that determination can be made, but I don't understand the second piece here. All right. Indeed, that analysis would require the executive branch to disclose to the court the domestic and foreign intelligence that undergirds the finding of an actual or threatened invasion or predatory incursion. So she's saying that we can't ask the executive branch because they can't disclose if there's a predatory incursion coming. What? Which would be contrary to law. Well, I don't know about that. Collecting cases in support. How about you include some of that support? Oh my gosh. All right, US XREL here. And then from the beginning, the AEA has been uniformly recognized as not subject to judicial review. Now, that's not true. Now, this is where our problem is here, because there is language in our case law saying it's not subject to judicial review as to whether or not it's allowed to be used. But there are questions specifically set out in the case law on whether or not a war's been declared. The court has said specifically that is reviewable, and the circumstances in the situation to make sure that it's appropriate stances. So I see where she's coming from here, but that does not seem like the appropriate application of the law here. What they're trying to say is the rationale that the president has during a time of war to say, I need to implement this, and the court saying, well, you need to tell us exactly why. Those kinds of questions are not allowed to be asked, right? Because we're in a time of war, and those are fundamental security questions. You can't ask those. But the court then went on to say, but whether or not we are at war, or whether or not the conditions that allow for the statute to be used have been triggered, that is justiciable. That is reviewable here. Using Chinese AI. I don't know. I don't know if this is Chinese AI. I don't know about that. All right, so I think this is a stretch here. Stretch. Oh my goodness. That's going to be a stretch. And perhaps this judge is getting a heads up from another perspective as to what the government's going to try to argue in these cases. But, she's a judge. And so she's saying, yeah, it's fine. That's a stretch. From the beginning, the AEA has been uniformly recognized as not subject to judicial review. Now, that again is not true, just how they're saying it. There are parts that are not allowed to be reviewed, but then there are parts that are allowed to be reviewed. So that's really interesting. Okay, hold on, everybody. I know you're all like, why can't you just read the case? Why do you keep yapping away? I can't help it. It's like this really weird little puzzle. And so sometimes I just have to. All right, here we go. Sometimes I have to just pull it apart. All right, here we go. Hold up. So let's look at the, this is what the precedent says, all right? It says here that the Attorney General here ordered the removal. So this is a case from World War II, all right? This is precedent. This is the Ludecky case. The Alien Enemies Act precludes judicial review of the removal order. 2, so the removal order, why you're removing them, is not is not allowed to be reviewed by a judge. And in this case, right, these were the schmatzis, and they had hearings. And in those hearings, it was determined that they needed to go, or if the secretary determined they needed to go through proper process. So that's what they're saying on number 1, all right? They're saying if it's determined that they need to go under the AEA, that is not reviewable. Does everybody follow me on that? And then 2, in circumstances of relations between the U.S. and Germany, there does exist a declared war, notwithstanding the cessation of actual hostilities, and the order is enforceable. The Alien Enemy Act, construed as permitting a resort to the courts only to challenge the validity and construction and to raise questions of the existence of a declared war and of alien enemy status. So this piece right here are the reasons that it can be reviewed by the court. All right, so the fact that hearings are utilized by the executive to secure an informed basis for the exercise of the summary power conferred by the act does not empower the courts to retry the hearings, nor does it make the withholding of such power from the courts a denial of due process. All right, so there you have it. There you have it, everybody. Did everybody follow me on that? This is a stretch, is what I'm saying. And she's saying, well, we can't review it. But the part that can be reviewed, she chose not to review. And according to case law, it should be reviewed. All right? Okay, thanks, Shellbell. All right, so before leaving this subject, the court also notes Southern District of Texas further concluded a presidential declaration invoking the AEA must include sufficient factual statements or refer to other pronouncements that enable a court to determine whether the alleged conduct satisfies the conditions that support the invocation of the statute. Okay, so that's, fine here. That is, while a president's declaration invoking the AEA need not disclose all of the information that they possess, it must identify sufficient information to permit judicial review. Look at this. So she's saying, well, we can't judicially review this, but we do need sufficient information to judicially review it. Like, that doesn't make any sense. What? Of whether the foreign nation or government's conduct constitutes a predatory incursion or like. She just said we can't have any of that. Now she's saying it has to be sufficient information. Like, what? This articulation of the law appears reasonable and correct to this court. Well, you're a little different, aren't you then? Here we go. Reasonable and correct. Good for you. And as the court finds below, this particular proclamation meets the standard. All right. Oh my gosh. The war, exactly, Navy vet, exactly. You know, you can't just be like, okay, well, these 5 words seem applicable. Like, there's more than 5 words, right? Yeah, I agree. Therefore, the court need not spend extensive time working out the nuances of its review. Really? My goodness. So she's saying, well, I don't really have to explain why. The court assumes, without deciding, that the Southern District of Texas is correct on this issue and proceeds accordingly. So we read the same case, but I'm not sure she read the same words I read. All right, so let me fast forward here, okay? Let's fast forward because I am heading over here to the tube very soon, my friends, because I do want to go through the latest Garcia filing. I don't want to skip over that. All right, I've got a pretty good idea here of what's going on. Let's hit the conclusion real quick. The case implicates significant issues, right? Resolving the issues, unflagging obligations to apply the law as written, whatever. When the court does so, it finds the proclamation now at issue complies with the AEA. Weird. And the court further finds respondents must provide greater notice to those subject to removal under the AEA than they are currently providing. Okay, so they're screwing it up. Having done its job, the court now leaves... What? The court now leaves it up to the political branches of the government. Oh, I'm not sure that's okay to say, ma'am. The political branches. I'm not sure Congress and the executive branch are political branches. I don't know. Of the government and ultimately to the people who elect those individuals to decide whether the laws and those executing them continue to reflect their will. There you go. All right, I disagree. Yeah, I know, right? She's been compromised. It's very possible. It's very possible, but I don't have enough to confirm that. So what I would say is I'm not going to say this judge is out of line. What I am going to say is that her legal analysis is missing some pieces from the Texas judge's decision. I don't think she read that correctly in, my view of it. And she's really stretching this judicial review language. Like, where did she cite Ludecky in here? Because, that is the law. Let's just peek here again. I'm going to fast forward. Holder case. Again, and I'm just skimming through this. She's using Webster's dictionary, right? Yeah, so I am okay, so this is a good one here. The Boumediene v. Bush case is a good one. That is historic. Let's see. Most federal judges begin the day with briefings that may describe new and serious threat. That's the quote she's using? That's different. Let's see. I'm just going to peek real quick and then do a wrap up here. Again, I'm just skimming through this, everyone. JAV, yes. Morton, yes. And, right. So, oh my gosh, and she even is pulling in cat. So good for you pulling in cat, although not really relevant to what you're ruling on. All right, I don't see Ludecky in here, which of course is the key precedent when it comes to that. Ooh, your soaps are on. Go on. You can't miss the soaps. Oh my goodness. All right. Here's the wrap up. First of all, we're in Pennsylvania. So we're in Pennsylvania, so that's the Third Circuit. So she's saying here that the AEA can be used, but the due process is not correct. The notice isn't okay. So, I'm the soaps. Really? I was thinking about my soaps. I tell you what, everybody, I'm going to take a minute here. It doesn't matter what country you're in. Soap operas are the same everywhere. And they're amazing. They all are amazing. I don't care what country it is. I'm just going to put that out there, all right? Because if you're watching soap operas and they're speaking in Mandarin, that's some crazy business going on. And I'm living for it every day. So here we go. We've got the Third Circuit here. Again, New York's already said no, that's not acceptable. Texas has already said no, that's not acceptable. DC as well. So now we've got one circuit out of 13, right, that is coming in and saying the AEA can be used, but your notice isn't any good. So this is exactly what happens. We've got this split decision. And honestly, once the courts decide the case that's being argued on the 15th, we'll have a better idea of how they want to deal with these exact kinds of situations when they're saying some of our circuits say that the AEA is okay. Some of them do not say they're okay. I would be shocked if this did not get appealed in the next 48 hours. Shocked, I tell you, shocked. We should have notice of appeal at some point so that they preserve their time. And then this should go further. All right, it should go further up because her analysis is very interesting. And when you have different views from different judges on the same issue, that's what the Supreme Court's for, right? That's what it's for. Table of Authority says Ludecki's here, but the search of the document doesn't find it. Oh my gosh, VC, I'm telling you. Sneaky. It might be in here somewhere. I'm just cruising through this pretty quick. So that overall, everybody, I'm not worried. This is not a case that's like, oh, that's it. That's the end. This is it. This is the end. No, I would say the reasoning here is a bit of a stretch. I don't know how the Supreme Court, maybe the Supreme Court will come in eventually and say, that this group could be seen as an arm of the Venezuelan government and therefore it does have this, predatory incursion going on. But if they do that, they're going to have to overrule the precedent that's been set previously, right? So, the other thing with invasion too, we have this issue of whether or not immigration or people coming into the country without proper paperwork, or they're coming in and intentionally with no paperwork, nor do they plan to have it, and, do whatever they want. So that question's already been answered by the courts as well. The Supreme Court's already said citizenship and immigration are not invasions. So that's the other piece of it. I think those are pretty big. Yeah. Episode of your, I know, right? I tell you what, these cases are getting bonkers. So one last thing that I will leave you with so that we don't feel too overwhelmed. And again, thank you everybody that told me this case had come down. Literally, I was like, oh, look at this case. And everyone's like, no, we got a ruling. All right, let's look at it. Thank you, everybody. But here's the last thing that I'll leave you with. All right, now in the U.S. Constitution, everybody gets so mad at me when I talk about this. We have something called, hold on, it just slipped my mind. I was just thinking about something crazy. It just slipped my mind. Okay, the incorporation doctrine. The incorporation doctrine is what we deal with for the Bill of Rights, the 10 Bill of Rights, right? The first 10 amendments. And the incorporation doctrine was set out because originally the Bill of Rights were not supposed to apply to the states. That's what the case law said. That's what the Supreme Court said. It said they don't apply to the states, only applies to the federal government. Now, then the Supreme Court came in and said through the 14th Amendment, through equal protection, we need to incorporate the Bill of Rights to the states so that the states and the Bill of Rights go hand in hand. So over time, we've had multiple cases where almost all of the Bill of Rights have been incorporated. What has to happen, though, is you have to have a case with that constitutional amendment in front of the U.S. Supreme Court so that they can incorporate it, okay? So, for example, Justice Ginsburg was the one that incorporated no excessive fines or bail out of the Eighth Amendment. That piece of the Eighth Amendment didn't apply to the states until just a few years ago when Justice Ginsburg wrote the opinion for the case that incorporated it, all right? She wasn't particularly happy. It wasn't really that great of a case, but whatever. So there are just a couple of amendments. Now, the Due Process Clause of the Fifth Amendment does not apply to the states because our Due Process Clause under the 14th Amendment is the one that applies to the states. But there are a few things like a grand jury indictment being required for criminal cases. That is not incorporated to the states, all right? The other thing that's not incorporated to the states quartering soldiers. I know, the Third Amendment. Now, the Seventh Amendment that has to do with, jury trials and civil stuff, that's also not incorporated. But the reason I bring this up, the Third Amendment states that you do not have to quarter government soldiers, essentially. All right, this was a big deal. It was in the Declaration of Independence. Jefferson's like, please, we need to get these soldiers out of our homes because they're messing with our stuff. All right, now, the Third Amendment has never made it up all the way to the U.S. Supreme Court. So the Third Amendment has never been incorporated. So the Third Amendment doesn't apply to states, except the Second Circuit. The Second Circuit, when it came to the National Guard and any other kind of military, has ruled on a case and has said in the Second Circuit, the Third Amendment of the U.S. Constitution does apply to us. All right, so that's the only place where it's been incorporated, and it wasn't incorporated by the U.S. Supreme Court. So the reason I share this with you is because there can be little differences between the circuits. We can have a circuit in New York saying the Alien Enemies Act does not apply. And then you can have one saying, well, it does apply. And then you can have another one saying it does not, and so on and so forth. And that's fine, as long as it's not hurting anybody, right? So that Third Amendment's not hurting anybody over here in the Second Circuit. So no reason to take it up to the U.S. Supreme Court. And the Supreme Court's like, we don't want to hear about it anyway. But when you've got something this huge, talking about deporting people or removing people from the country under a statute that may or may not be appropriate to be used today, right now, that's a huge issue. So the idea that the circuits are split isn't really what the problem is. The problem is the repercussions of having half of the states saying this is a time of using the Alien Enemies Act and the other one saying this is not. That right there is just a fundamental piece that can't continue to go on. That's why this issue will make it to the U.S. Supreme Court. Okay, so there you go. There's your free lecture. There you go. A little bigger bang for your buck on that one. Oh my gosh. So with that, my friends, hopefully that explains everything. So you don't need to be too worried. I think it's very interesting, though. We've got another perspective on it, and I think that's great. We want to get all of the views that we possibly can so that we can work and figure out the best route for us, right? So no clue what that was about. No problem. No problem. Yes. So happy to go over it. One more thing then before I leave you all over here on the TikTok. And that is, hold on here. Let me make sure I have it. Let me make sure. Here we go. This is the most recent filing in the Abrego Garcia case. This was just filed here. This is a document I'm going to go over to the tube and read. All right, so I'll be heading over there in about 20 minutes. If you want to come find me, my handle's the same over there as it is here. And I will be focusing that live on going through and reading the latest filing, because we do have some interesting new pieces here that have come out of the 4 depositions that have already been done. So with that, I'll be heading over to the tube here in about 20 minutes. Thank you all for coming and hanging out and joining me tonight. I really appreciate it. Hopefully I can come, or you will come over and hang out with me for part 2. So this was the pregame show, and then we're heading over to the game. See y'all later.